Yeah. Welcome everyone on Krishna's tutorials. I am Sonali, educator, who will be taking up the task of dealing with first year LLB first semester subjects. Okay. So, yeah, paper 1, which we are going to see, is Law of Contracts, which is a high weightage subject because as up to 8 to 10 questions relating to it appears in All India Bar Exam, JCJ exam, CLAT, UGC net with UGC net law, then law officer exams conducted by banks, etc. So let us see the scheme of syllabus prescribed by Board of Studies, Usmania University. Okay, yeah, I hope it is visible. Yeah. So the whole syllabus which you are finding is divided into 5 units. So law of contracts is to do till unit 4 only. In the fifth unit, we are going to deal with another act, which is Specific Relief Act 1963. Okay. Law of contracts, that is the Indian Contracts Act 1872, is up to unit 4 only for the first semester. Okay, so 1 to 15 sections are dealt in these 4 chapters, first 4 chapters. Okay, yeah. So first unit is much like a introductory unit where you all see the basic definitions. Okay, different definitions which one is supposed to go through is seen in the first unit. Second unit is somewhat, yeah, you can find these concepts here, addition of few more concepts here. Then the third unit, which says about how a contract is to be discharged, who can actually perform a contract, all of those things. So yeah, fourth chapter concludes our I mean, it concludes the law of contracts for first semester. Okay, so these 4 chapters are relating to uh, Indian Contract Act 1872. Then comes the last final chapter.
Hello, if I may just interrupt, can you one more time click on the slideshow? It is still in normal mode.
Okay, fine.
Yeah.
Yeah, thanks for that. Yeah, yeah. So these are the 4 chapters dealing with uh, Indian Contracts Act 1872, which we are going to deal. We are particularly going to deal with the important questions, which are repetitively asked by the semester and exams conducted by Usmania University. Okay, yeah, yeah. So let us understand this. Let us begin with the basic understanding of law because, yeah, first we are supposed to know what law is before we dwell into law of contracts. What is a law? My understanding on law is that it is nothing but rules and regulations imposed or framed by an authority. Okay? Nothing but rules, regulations framed or imposed by authority. Okay? Say the government. Okay? Now, this was my definition relating to my perspective on law. But in law, I mean, a famous jurist by name John Salmon says the body of principles, okay, all principles put together forms a body of principles. So, such a body of principles recognized and applied by the state in the administration of justice. Okay, why are laws needed? So that we attain justice. Okay, we all need a proper machinery so as to attain justice. That is why laws are made and they are applied by the state. Okay, so as to attain justice or provide justice to various people, to various persons. Yeah. Okay. Example. Now, let us suppose, for instance, you are not supposed to drive your vehicle on wrong side of the road, right? Or even you are not supposed to park the vehicle at a no parking area, right? So, just in case you have not followed those rules and regulations, so what actually happens? So, not abiding with such rules makes you liable. Ante, traffic police will take an action against you. They will impose a penalty, fine, or in some circumstances, your vehicle is also seized. Okay, this is nothing but there is a law which you are not following it. That is why you are into, I mean, you are facing the liability. Okay, you are actually, uh, yeah, so you are held responsible for your wrong which you have committed. Okay. So laws, who is actually making all these laws? So laws are framed on various subjects. So this one is law of contracts. There are many other laws like that. Motor Vehicles Act is there, right? Consumer Protection Act is there. So who are those people who are making these laws? So, laws are framed on such subjects, I mean, various subjects, by legislature. Now, who is this legislature? Legislature is nothing but at the central level, we have parliament, and at various and in different states, we have assemblies. So, parliament, state assemblies put together are called as legislature. Okay, yeah, this is what is I wanted to convey. So it is the legislature which is making laws. Okay. Motor Vehicles Act, Law of Contracts, all these acts, all these laws are made by, written by legislature. Okay. Yeah. So, so law is nothing but a command. If not obeyed, it will impose sanction. Ante, it is a command. You are supposed to, it is like what I'm saying you're supposed to do. And if you're not obeying that, it will attract punishment. Okay. That is what we are seeing these days. Yeah. Was the basic understanding of what law is. Right? Now going to law which pertains to contracts. Okay. Yeah. Yes. So this is the introduction relating to law of contracts. So, yeah, every day, see, you all the human beings are social animals, in the sense they can't survive all alone. They are always getting into contact with many people day in and day out. They are not just meeting, they are also creating contracts with them, knowingly or unknowingly. Okay, from the time you step out of your home till the time you get into your home, you are indulging yourself in various contracts. So for instance, you are taking a bus to reach your workplace, so you're purchasing a ticket, right? So it is a form of contract which you are entering into by the TSRTC, right? You're paying something to purchase a ticket. Okay, so it is a type of contract. Okay, another one, ordering food from a restaurant. You are walking into a restaurant to have a dinner, you're paying for the food, enjoying the services. So here there is a form of contract, right? You're paying something, restaurant is supposed to provide you with good food, right? This is nothing but a kind of contract. Yeah. Purchasing a newspaper from a stall. You're paying something, right? So even there, after payment, don't forget to take the newspaper. So they are supposed to provide you, right? You're giving something, they are providing you something. Just imagine you're paying something and you're not getting. Just imagine you have ordered earphones from an online shopping website. You have placed an order, also the money got debited from your account, and imagine that earphones have not reached you. Or just imagine, instead of earphones, uh, a soap has been uh, delivered to you. So in that case, you can approach court. You can approach a consumer forum, so as to, yeah, so as to take action against them, right? Because they have not fulfilled the condition of the contract. So contract with you and the online shopping website was that when you are paying so and so amount, say 500 rupees was the worth of earphones, you have paid it, right? So online shopping websites work, sorry, their duty was to send these earphones to your place. They have failed to perform their duty, so you can bring an action against them, right? So you can claim damages from them. Damages here, in the sense, in law, damages means compensation, right? Because they have done a grave mistake here. Because they, I mean, it was a contract between you and the online shopping website which they did not abide to. Okay. Yeah. So all these are the examples of contracts. Now, it is always seen that both the parties to the contract has rights and duties and are under obligation to fulfill them. So, yeah, let me say you here, parties. Why are we using the term parties? Because there are always two or more persons involved in a contract. Okay, it is not just you and some other person. Okay, two parties or two or more parties. Okay, yeah, both of them has rights and duties. Ikkada, the example which we have seen, yeah, you are right. I mean, you have placed an order, right? So your right is to get the earphones. Yeah. In the same manner, the online shopping website duty is to send you the earphones, right? And also, it is your duty to pay the charges of the earphones, right? Yeah. So, nothing but a contract creates rights and duties between the parties. Here, the person has, I mean, the person who is placing an order has rights as well as duties. In the same manner, the opposite person, that is the online shopping website person, also has some rights and duties. Like his right is to charge you for the earphones which he is sending, also charge you with the delivery expenses, right? So here in a contract, many rights and duties can be seen. Okay, and are under obligation to fulfill them. Like all the rights and duties, both the parties are supposed to follow them. Okay, obligation in the sense they are supposed to particularly follow them. If they don't follow, then an action can be brought against them. I think it made clear to you all. Yeah. So this is just the introduction of the contracts. Like why contract comes into picture and what all happens. Yeah. So now all these contracts, okay. So as I told you that daily we come into, we make many contracts with many people. Like I have told you the bus example where you purchase a ticket, or the earphone example, or the restaurant example. So all these contracts are governed by, okay. So there is, yeah, this particular enactment or an act which was brought in by Britishers back then in 1872. So, the Indian Contract Act 1872 came into force on 1st September 1872. Okay, so it is before Independence Era Act, which we are still studying. Okay, yeah. So previously it was applicable to the whole of India except Jammu and Kashmir, but now it is applicable to the whole of India including Jammu and Kashmir. Okay, yeah. Now in the beginning I have told you that only the first four units, I mean the five units totally, of which only four deal with law of contracts. Yeah. So section 1 to 75 are called as the general principles of contract, which we see in those first four units. Okay. Yeah. Which is forming. part of your paper 1 law of contract subject in the first semester. The now after 75th section, the other coming sections are forming part of your syllabus in the next semester. Law of contracts 2 you will be dealing in second semester. Okay, so these are the general principles of contract which are seen in almost all the contracts which you come across daily. Okay, so you are supposed to be thorough in this, what do we say, sections, because many questions comes relating to them. Okay, so one is supposed to be thorough with these 1 to 50, 1 to 75 sections, so as to have in-depth knowledge about the contracts and all. Yeah, so from where is law of contracts coming from? Okay, so what paved the way for the Britishers to bring law of contracts into, I mean, what made them to write this law called as law of contracts? We can say the parent of law of contracts is law of merchants or the mercantile law. Now you may be thinking, what is merchants? I mean, who are merchants? What is mercantile law? Let us know about that. Mercantile person or simply a merchant. Say, I mean, if you all remember, I mean, there used to be one lesson in our English book, supplementary book, while we were students, The Merchant of the Venice. Yeah. So, yeah. So, merchant is a person. Uh, he might be a person, he might be a single person, or a partnership firm, or a joint stock company. So, this is the explanation which is provided in the PPT. But then, to be simple, merchant is a person who's dealing with goods and services. His work is to supply goods and services. Okay, he is a trader actually. He trades on goods and services. He is a businessman. Okay, for your understanding, he is a businessman. He deals with goods and services. His work is to earn profits. Okay, his business is to earn profits. I mean, uh, hi- his work is to do business and earn profits for himself. So, such a person is a mercantile person or simply a merchant. Okay. So, what is mercantile law? Mercantile law, I mean, the law which is applicable to those persons. Now, see, these people are purchasing and selling goods to customers. Don't you think there will arise any problems in between? Like, right? So, let us imagine this merchant has, sold some 100 t-shirts to a retailer. So some of the goods got damaged, and the retailer is supposed to claim damages from him or compensation from him. So how will he do that? So this mercantile law, okay, which was very before the law of contracts, that law governed the conduct. Like that retailer will get his, damages from the merchant by with the help of mercantile law. Okay, so this is an old law. This is very old, even before Indian contract law I'm speaking about. Don't get confused. Okay, mercantile law is like it existed before 1872 law, that is Indian Contract Act. So I'm just saying you from where Indian Contract Act came into picture. Okay, so this is the history which I'm saying you about. So mercantile law, legal rules which are connected with trade, commerce, and industry. Okay, yeah. So from here, the mercantile law concept came law of contracts. Okay, so now please understand that law of contracts does not deal with only the merchants or mercantile person. It deals with you and me, okay, and also the merchants, in the sense, to all the businessmen, to all the individuals, to all the companies, to all the partnership firms. For all of them, law of contracts is applicable. Okay, yeah. And the same Indian Contracts Act 1872 governs them. Okay, yeah. Now, what is the object of law of contract? Why was this law made? Okay, now, if you rent a home in Hyderabad, or anywhere. Hmm? You are supposed to abide, ante you are supposed to follow, I mean you are supposed to, yeah, abide by the terms of a lease agreement, right? If you are taking a home, you are supposed to make an agreement. I mean, the landlord will sign you an agreement. Conditions will be put forth that you are supposed to pay so and so rent at so and so time, before so and so time, right? So many such conditions will be imposed there. Signing means you have entered into a contract. And uh, let me say this, that you will read the contract and then only sign, right? So it means that you are I mean you are well aware with the terms and conditions, you have understood them well, then only you are agreeing, then only you are putting your signature. Okay. Now, in the same manner, now you have put your signature, you have taken the home on, I mean, you are staying there. So it is a type of contract which you have, uh, which you have got into with the landlord. Okay. Sorry. Yeah. In the same manner, an employment contract has all terms and conditions written in it for the employees to comply with. Okay. Now you got a job at some office, at some workplace. So there the employer, the person who is providing this job, will already have an agreement. I mean, yeah, they have some agreement. They'll make you understand all the terms and conditions, like at what time you're supposed to be in the office premises, what sort of work will be provided to you, right? So what will be the salary, what will be the perks, all these things will be included in that contract. And it will also specify that in case of any default from your side, if you have indulged in any wrongful activity, you will be liable for that. Like, if you are a person, like, let us suppose this employment contract is for a factory worker. Just imagine this factory worker, while working in a factory, damages something. Okay. uh, because of him some goods got damaged. So the employer will include a condition that in case if this particular person has caused me any loss, he is liable to pay so and so amount to me. Okay. So all such clauses, terms and conditions are included in the employment contract. And this person, employee, is supposed to read all those things, understand them well, and if he is agreeing to all of them, he is supposed to sign it, saying that yes, I'm agreeing. We both are having a contract now. It means that when he has signed. Okay. So both the parties are supposed to comply with the condition, I mean, comply with the terms and conditions. Let us suppose this person, employee, is coming late to the office or the factory. Then what can be done? Deductions can be made, right? And if this person, and also it is the duty of the employee to work thoroughly, right? In the sense, he is supposed to work according to the prescribed standards. He cannot work as he likes to. Okay. Like what his supervisor says, he is supposed to do that. So both of them are having rights and duties. Like, at the end of the month, employer is supposed to pay him salary. It is the right of the employees to ask for salary, and it is also the right of the employees to get perks. Perks are nothing but extra income in case if they are working for extra hours. So all these are written in contracts. Okay. So rights. So in contract, you may ask me, what is a contract? Contract is nothing but all the terms and conditions are included in it. Okay. Rights and duties. Like, what are the rights of employees? They can ask for lunch breaks. Yeah, they can go for paid leaves or something in case of health issues or something. Yeah, all these aspects are included in a contract. Okay. Now, in case any person, hmm, in case any of the party to the contract goes against any of the clause written in the contract, okay, Any one person, hmm, he is doing something which is not written in the contract. No, sorry, not written in the sense he is doing something which is against the contract, then the opposite party can bring an action against him. That is why contracts is such an important subject these days. So that is why we are learning this subject, to know how, to know, I mean, what are the benefits of it. Yeah. So, law of contract ensures that rights and obligations arising out of a contract are honored, and that legal remedies are made available to an aggrieved party. Aggrieved party in the sense the party who is at loss. Okay. So, aggrieved party. So, here the factory, in the example which I gave you, factory owner, I mean the factory worker damaged goods. So who is at fault here? Factory owner is at fault because his goods are destroyed by factory worker while working. So aggrieved party ever ikkada? Aggrieved party is the factory owner. Factory owner can bring an action against the factory worker. Okay, because he has not worked perfectly, he acted negligently. Okay, his negligence has caused him some damage. Okay, some damage to his goods. So that has resulted in a monetary loss. He can go to the court. Okay, he can pray there. He can pray there for, you know, he can pray there to provide him with compensation. Okay, yeah. So it ensure law of contract ensures that rights and obligations arising out of a contract are honored. Both of them, I mean, all the terms and conditions are to be honored by both the parties. Okay. And that legal remedies are made available to an aggrieved party, the party who is at loss. Court provides him remedies. Okay, court provides him with compensation so that his loss is, make made good. Okay, so that he is put in the previous position, like nothing has caused damage to him. So that position he is put into by the courts against the party failing to honor his part of agreement. Okay, so both the parties are supposed to abide by the contract. If they fail to do so, if they are going against the contract, then they should be well aware that courts are there to impose them with liability. Okay, yeah. So this act lays down the basic principles of how contracts are formed, how they are performed, and how they are enforceable. Yeah, how they are made enforceable. So these three things you need to remember: basic principles of formation, performance, and enforceability of contracts is dealt in Indian Contracts Act. Okay, yeah. Now, why do you think uh, in 1872 Britishers thought of, coming up with a thing called law of contract? So here is the purpose. Like, what was the purpose for them to bring law of contracts into picture? Hmm? Yeah. So this law of contract provides an effective legal framework. Okay. It is like it provides a good machinery for contracting parties to resolve their disputes. And everything is into stages here. Okay. There is no, what should I say? There is no, I mean, yeah, wait a minute. Yeah. So there is a defined legal framework here. So that there is no place for confusion. So yeah, there is a proper procedure prescribed for the contracting parties to resolve their disputes. So in case of consumer complaints, consumers go to the consumer forum. In case of some other problems, some other courts are there. Also the procedure is different for different sort of issues, disputes arising. Okay, like if somebody, let us suppose, uh yeah, So there are various courts available where, aggrieved party, the party who is at loss, can go and claim for damages. Okay, and regulate their contractual obligations. So this is the purpose of law of contract. Okay, it is a platform which provides legal framework, okay, to both the parties to resolve their disputes. Yeah. Now, definition of a contract. Let me say this in law. Okay, you are supposed to go through, I mean, at least for each topic, one definition is mandatorily prescribed for you all to remember. Okay, so the subject is like this, and you're supposed to do the needful by, you know, uh, grasping the definitions. Yeah. So let me say you all, in various exams, which I have told you in the beginning, definitions are asked. Like in the first definition which you are seeing, I mean, the first definition which you are seeing, they'll just quote that and ask you or give you four options that who has told this thing. You are supposed to figure out, right? So that is the importance of definitions in law. I mean, this clause, what I told, applies to all the subjects of law. Okay, so in competitive exams, definitions are asked. You are supposed to identify which person has told that thing. Okay, so yeah, Salmond is a famous jurist whom you will come across in almost all the subjects. Okay, so he has defined many concepts in his way, which you are supposed to remember. Okay, so in the same fashion, he has come up with a definition. He says a contract is an agreement creating and defining obligations between the parties, which I told you just before. Contract is nothing which has terms and conditions, rights and duties. Okay, yeah, it creates and defines obligation between the parties. Parties, in the sense, two or more persons are involved. That is why parties word is used here. Okay, this is the definition by Salmon. Now comes the second jurist. Yeah, his view on contracts is every agreement and promise enforceable at law is a contract. Is what according, I mean, this is what Pollock has told. Yeah, these both are, I mean, the above both of them were jurists. Now, our act, in the sense Indian Contract Act 1872, has also defined, like, let me say you all, in subjects, I mean, in all the acts, mostly it is seen that section 2 is the interpretation clause. Okay, which means in section 2 most of the concepts are defined there. Okay, so here we can see the same thing. Section 2, clause H of the Indian Contract Act 1872. This particular section and clause defines the term contract. Okay, yeah. So this is easy to remember. Just a single sentence. Please remember this. An agreement enforceable by law is a contract. Okay. So let me say you all, I don't want to confuse, but then let me say you all that all agreements are not contract. Okay. All agreements are not contract, which you will now, you might be unable to understand, but in the subsequent PPTs you will understand them. Okay, just remember, an agreement enforceable by law is a contract. So here, to be precise, there must be an agreement plus enforceability. Okay, which is capable of performing. Okay, I say you, please go and make it rain today in Hyderabad. Can you do so? You cannot. It is not in your hands. So, such a contract is non enforceable. You can't enforce it. Okay. So, enforceability should be there in that. I will, so I just mean to say it must be enforceable. There are certain essentials for a contract which we will be seeing in our later classes. So yeah, for now remember this formula sort of a thing. Agreement plus enforceability makes, I mean, leads to a leads to the birth of a contract. There must be an agreement, and it must be capable of performing. Okay. Also, it must be legal in nature. Illegal things cannot be done, and you can't call it to be as contract. And mind you, you cannot go to the court for asking, you know yeah, for asking compensation for an illegal contract to be, yeah, to be done. Okay. So here is another example of a contract. Yeah, an agree. Sorry. Yeah, an agreement to buy certain specific goods at a agreed price. Say, okay. Yeah, let me say you all. 100 bags of fine rice you want to purchase from a rice trader at rupees 1500 per bag. Okay. After negotiating with him, maybe he was saying you 2000 per bag. Okay. So in your negotiations, you both have agreed. You both, in the sense, you are the purchaser, and that person trader who is having a shop of rice is the uh, yeah. So both of you agreed at this particular price. Okay, 1500 rupees. So both of you agreed, in the sense there is an agreement. Okay, is a contract as it gives rise to a duty enforceable by law. Now, you both have agreed to it in the same fashion. Okay, so both of you know that 100 bags of rice is to be supplied, and you are supposed to receive 1500 per bag. So the trader will be getting 100 into 1500. Okay, the so and so amount the trader will be getting. So just imagine, you have paid the price, whole price. Okay, 15, yeah, 100 into 1500, whatsoever it gives you, you have paid it in advance to the trader. You told him to, today is 8th, you provide me on 15th. So on 15th, you are waiting for the delivery of 100 bags of rice. You see that it is not delivered, right? So you are the aggrieved party. You are at loss. You have the right to approach to the court. Okay. So because there was a contract between you both, that he, on payment of so and so amount, he is supposed to deliver you so and so item. Okay. Both are having rights and duties here. So in case of dishonoring of this agreement, okay, the default party can go and sue the person for breach of contract. Okay, he has gone against the contract. In simple terms, he has gone against the contract. He has not complied with the contract. Okay, so this is the example of law. I mean, this is the example of a contract. Okay, yeah, okay. So, what is an agreement? I think we have came across this word many times in our previous slides. An agreement may be or may not be enforceable by law. Okay. So I come into an agreement with you that tomorrow we will do an activity which is illegal in nature. Okay. Can it be enforceable by law? It cannot be enforceable by law. You can't say, you can't go to the court and say the judge that we both have planned something illegal and this person is not doing that. I mean, this person is not agreeing with me now. He's going against the agreement. You can't say that. I simply mean to say illegal things cannot be enforced. Okay. So an agreement may be or may not be enforceable by law. Okay. And so all agreements are not contracts. Okay. Only those agreements are contracts which are enforceable by law. Okay, anything which is against law cannot be enforced. Okay, I'm repeating it again. Anything which is against law cannot be made into an agreement. I mean, cannot be enforced by law. So it can be concluded here that this is a statement, an important statement from the point of view of many exams. Like even in your end semester exams, this statement will be given, and you are supposed to write 3 4 pages supporting with what do we say, case laws. Okay, so this is an exam important thing. All contracts are agreements. Okay, contracts are made only when agreements are made, but all agreements are not contracts. Okay, I understand that at this particular moment of time you'll be little confused. You'll arrive at clarity only when you go through 3 4, what do we say, case laws supporting this particular statement. Then only the picture gets crystal clear to you all. Okay, we'll go through them in our next, what do we say, uh, PPTs in the subsequent classes. Yeah, so here, section 2, clause E of Indian Contract Act 1872. Remember, section 2E. 2H was contract, 2E is agreement. I mean, the definition of agreement can be seen at section 2, clause E. Okay, it says every promise and every set of promises forming consideration for each other is nothing but an agreement. Okay, don't worry, this part from here onwards I'll deal it in an elaborate manner in the next class. But for now, understand that agreement is defined as every promise and every set of promises forming consideration for each other. Okay, promise is nothing but is an accepted proposal. So here remember, proposal is also called as an offer. Okay, so when you offer, yeah, promise is an accepted proposal. So what is an agreement? Agreement is nothing but offer plus acceptance. When you offer something, when you offer a tea to somebody and the opposite person accepts it, it is nothing but an agreement between both of you. Okay, so yeah, so agreement is an outcome of two consenting minds. In law, particularly in law of contracts, we call this particular thing, that is two consenting minds, as consensus ad idem. This is an important short answer question for your end semester exam, which will carry some 5 to 6 marks. Okay, now agreement is an outcome of two consenting minds in the sense, yeah, you both you both are supposed, I mean, you are the person who are getting into contract, opposite person is also getting into a contract with you. Both of you are supposed to understand the subject matter in the same sense. In our previous example, yeah, 100 bags of fine rice at rupees 1500 per bag. Okay, you understood it in the same fashion, and also the seller has agreed to this sentence. Only then contract came into picture. Imagine, you agreed for 1500, but the seller is saying beyond 2000, less than 2000 per bag, I'm not going to sell you. Is there any consensus added in there? No, because you are thinking, you are of some opinion, he is of some other opinion. You both are not having clarity. You both are not having the same, what shall we say? Yeah, you have both, I mean, both of you are having conflict here. So you have not understood, I mean, you both are not consenting to the same price. 100 bags, 1500 each bag. You both are not consenting. One is consenting, the other person is not consenting. So there in that situation, we can say that there is no consensus addendum between you and the seller. And when the seller agreed that yes, it's okay that you pay me 1500 per bag now, I'm accepting to deliver you on 15th of Feb 100 bags of fine rice at your place. When he's saying that, it means that he has given his consent. Both of you now have understood the same thing in the same fashion. Okay, the terms are clear to both of you. You both of you know what are your rights and duties. Okay, he is supposed to deliver on 15th Feb, and you are supposed to pay him the price, that is 1500 per bag, and he is supposed to deliver it on time. Yeah, all these things both of you understood in the same sense. This is nothing but consensus ad idem. It is an essential ingredient, essential condition, okay, for a valid contract, which we will be seeing in our subsequent in the sense coming up classes. So here I want to stop my today's class. Just a minute.